begin by making an overall observation that after all the charges that were leveled and all the evidence particularized of impropriety against the governor chose not to take the witness stand and answer to any of those charges. The question is this: when a charge is leveled and the evidence, the quantity and weight of which has been played before you by way of witness testimonies, documentary evidence, and video evidence, and the person called to account refuses to take the opportunity given to him to account, what inference will you draw from that? When you begin deliberating, I invite you to consider that aspect of this case. Having said that, there are certain matters that arose in the course of clarification by senators that I wish to address myself to as part of these closing submissions. We stand here as lawyers, Mr. Speaker, sir, distinguished senators, as people who have to offer guidance on the harmony or otherwise between the evidence on record and the law established. The conclusions to be drawn from that evidence on record and the law established are purely yours as judges, and as participants in the justice process, we have no choice but to accept your verdict unless one pursues any other option known to law. So two questions arose, Mr. Speaker. Distinguished Senator Onyonka presented to the expert witness a question in the form of that both the passwords and the usernames to this system were made accessible to all MCAs. Mr. Speaker, sir, let the Hansard record me as saying that there is no such claim made by any witness before this assembly. The witness before this, the evidence before this Senate has been and remains this. 2 links were sent to MCAs. Link number 1 communicated IPPD numbers which were to be used as the user names. A username, to my lay understanding, is like my email address, which I put on my letterheads and put on my contact numbers, which is itself not a risk. The second link was the voting link. It went with the instruction that every individual MCA will use their own ID, national identification card numbers to vote, so that the aspect of the passwords were never communicated to everybody at all. I have been a participant in the processes of this House, both as an academic and as an advocate, as I'm doing, and I know that there is a rule in this House of accuracy of facts. Whenever one makes a decision, the accurate fact is that no witness, both from the governor's side or the assembly side or the expert, stated anything to the effect that people's ID numbers were communicated to everybody. It is important that that fact is captured by the record and the decision makers so that a decision is made on the correct set of facts. Secondly, a question arose from the clarifications as to whether there was a possibility of geolocation of these IP addresses. I can do no better, because I am no IT expert and cannot pretend to be one, than to look at this Senate's own appointed expert. At page 13 of that expert's report is IP address lookup. Page 13 of that is IP address lookup. Then it says geolocation data from Then there are some details there, but I'm interested in the country, Kenya, region, Kericho. I do not know what conclusion you can draw from that because I am no ICT expert, but the only evidence available to us shows some geolocation of this IP address to Kericho. I thought that is an important question for you to take into account. Allow me to then address the question that has now emerged as the question of the voting process. And let me observe this. Number one, whereas this House is not strictly bound by rules of evidence, this House, in fact, applies rules of evidence, by which I mean it does not completely disregard rules of evidence. That is why witnesses swear their affidavits as required by rules of evidence. Witnesses take the witness stand and are sworn as required by rules of evidence. Witnesses are examined in chief as required by rules of evidence. Witnesses are cross-examined as required by rules of evidence. Witnesses are re-examined as required by rules of evidence. So the point I'm making is that whereas you are not strictly bound by rules of evidence, your rules don't disregard rules of evidence. There is a presumption in evidence law called presumption of regularity. That when you are presented with official documents, Kenya Gazettes, official government reports, you presume them to be regular until credible evidence to the contrary is proved, is presented. The County Assembly has presented you evidence of 33 MCAs voting for the impeachment of this governor. The County Assembly has given you an expert witness who has said, as far as is concerned, these 33 MCAs voted for the impeachment of this governor. The governor has presented an expert here. That expert has not controverted that factual content of the official document, the Hansard, that in fact 33 MCAs voted for this governor. This Senate, faced with those two witnesses, has called its own ICT expert. That ICT expert has returned a verdict that from the information available to him, in fact, 33 MCAs voted for the impeachment of this governor. It forces, therefore, it demands, therefore, us to conclude that no evidence has been presented that challenges the Hansard of the County Assembly and the resolution of the County Assembly that 33 MCAs voted for the governor. Let us look at the attempts to challenge that position. First, the records will show you that the governor's claims before you were premeditated claims. He entertained these claims in advance of the voting process. His advocate is captured in the Hansard of the County Assembly saying, we know that people have voted for or will vote for 4 members of the County Assembly. This was said in advance of the voting. Let us look at this carefully. An MCA comes and tells you that 18 MCAs left their phones in the car. The MCA who came here, Honorable Anita Mibei, confirms she had her phone inside the chamber. It means the allegation that these MCAs left their phones inside the car is not worth of any credit. That's what it logically means. She introduces a new nuance of her phone going off, which was not contained anywhere in the affidavits she presented before this House. All MCAs who came here confirmed that they were all in the House. All the 47 MCAs were present in the House. all the MCAs were given an opportunity to vote. The Speaker announced that all of you have an opportunity to vote, and here is the voting method. And if any one of you has difficulties, go to the gadgets presented to you by this assembly and be assisted to cast your vote. No MCA says, I attempted to cast my vote as guided and anyone frustrated me. No MCA says so. The governor makes a claim that 4 MCAs did not in fact vote. The system returns them to have voted. One of those 4 MCAs comes before you with another affidavit. She's called Edna, and says, in fact, the contents of the other affidavit is wrong. In fact, I voted, and in fact, I never signed the other affidavits. What is the net effect of this development? The net effect of this development can only be one: distinguished senators, and that is the claim that these 4 MCAs did not vote is not believable. That's the only conclusion you can draw. So, let us face this. The governors, I'll come to that in a short while and I'll begin analyzing those witnesses one by one. But let me address you on the lack of logic in the totality of the governor's case theory. There were 47 MCAs entitled to vote in Kericho County Assembly on the 15th of August, 2025. If you believe, as the governor believed, and as his council believed, that someone voted for you with your credentials,